Unfortunately, what we think of as a contract between an employee and a company, where an employee releases his rights to sue the company, many courts are not enforcing those agreements because they view them as a violation of public policy. There are several instances where whistleblowers have brought complaints to management and then have voluntarily resigned from the company. The company gets them to sign a waiver and release in return for a severance package saying they're not going to sue the company. Then the former employee turns around and does precisely that and sues the company. Courts have held that those agreements are not enforceable unless certain conditions are met. And the main condition there is that the company has to disclose the employee's allegations to the government. And if that disclosure occurs, then it's presumed that the government has at least been made aware of the allegations, and that overrides the public policy argument, and the court would enforce the severance agreement at that point. Whistleblowing employees are resentful of the company, they're nervous, and they presume that anything that happens in the workplace is happening because they blew the whistle. So when companies take any form of disciplinary action against a whistleblowing employee, the company has to make sure that there's a valid basis for it and that the action is completely unrelated to the whistleblowing. So an employee who's got a poor performance record and the company is ready to lay off people, that person can be subject to layoff as long as there's a legitimate reason separate and apart from the whistleblowing for taking that action against the employee.